So I find it hard to believe that you didn't know 3 years ago or 4 years ago when this started, and apparently you didn't do anything about it.
We do not recognize the debt that has been brought forward. It's not a debt that's familiar to us or that we recognize.
Why not? You're telling me that somebody fraudulently used your account. I see Mr. Goff and counsel for LVNB funding are back, so let me recall that matter. This is LVNB funding versus Kevin Goff, filed 26-41719-GC. Counsel, were you able to reach a resolution with Mr. Goff?
Connor, what did you do with my pad? What did you do?
That's not our case.
I muted her. That's Sally Sanders.
All right. Sorry about the interruption. Mr. Counsel, was there a resolution in the Goff case?
There's been no resolution, Judge. I think we're going to have to go forward with this motion today.
All right, Mr. Goff, do you concur that there's been no resolution?
Yes.
All right. Counsel, go ahead and argue your motion for summary disposition.
Yes, Your Honor. This is regarding a credit card that was opened, originally financed by Web Bank. There was local purchases made on this account, and there was a balance accrued. By using the credit card, the defendant consented to the terms and conditions of the credit card. There was a payment made on the credit card on January 6th of 2022. Due to payment ceasing, the account went into default and was charged off with a balance of $520.72. Thereafter, the account was transferred through a lawful assignment and sale to LVNB funding. The defendant was provided notice of the sale and assignment by the goodbye letter. The amount of $520.72 is accurate, and that's demonstrated by plaintiff's affidavit of indebtedness and ownership of the account. I'm asking the court to grant this motion under MCR 2.116 C9 and or C10 for no valid issue of genuine fact and no valid defense. And with that, I rest, Your Honor.
Thank you, counsel. Mr. Goff, do you have anything that you'd like to say on your behalf?
Yes, Your Honor.
We do not recognize the debt that has been brought forward. We did not receive any prior notice to being served. We do recognize the evidence that was provided, but it is not something that we have recognized. It's not an account that is familiar to us. We do see the exhibits that have been provided as well, but it is not recognizable by us. The plaintiff had asked if we had filed a police report for it, but we had not, because it was something that we hadn't known was an issue until being served. We have asked to have it dropped. We've provided discovery. And then the final thing we added is he is a disabled veteran, total and permanent. And so any judgment that might be made against him per MCR ruling would not be valid. And that is what we have, Your Honor.
Well, the judgment issue or the collection issue as being a veteran and all that kind of stuff doesn't have anything to do with whether or not they're entitled to a judgment. So the only question before me today is whether or not they're entitled to a judgment. I have in the court file a proof of service indicating that you were served on February the 4th of 2026 with the summons, which contained a copy of the complaint and put you on notice of what the debt was. So what is your claim that you don't recognize the debt?
It's not a debt that's familiar to us or that we recognize, and no contact was made to us prior to being served. We agree with that. We were served on February 4th, but we had no knowledge of it prior to that. There were no communications made to us prior to that.
In the motion for summary disposition, there's copies of documentation indicating that purchases were made and payment was made, and it goes to the exact same address that was given in your answer.
Correct.
How do you say that you didn't have, it's not your debt then?
We did not recognize any of the debts that were on this on this account or the payments made for it. We do see there are local payments. We do see that, but we did not receive any statements and we do not recognize that account.
I don't understand when you say you don't recognize it. What are you trying to tell me?
It's not something that we've had. We do not have an Advent card. We have not had an account with WebBank. So it's everything is the account numbers are unfamiliar to us that made the payment. What was provided in here is all unfamiliar to us.
What did you do back in council? Is this payment made in 2026? Is that what you're telling me?
No, it was made in 2022. It was made
2022?
Yeah,
All right.
January 6th of 2022. So there's a couple statements in here, Your Honor. If you were to look at them, the first statement has the purchases on it, and the second statement has the payments on it. And then after that, it is just late fees and interest.
Right. So I see a payment or a purchases made in November 28, 29, December 5, and December 6 of 2022, and then a payment made in January 6th of 2023, apparently. And all of them have addresses, name and address, the exact same as Mr. Goff put in on his answer to the current court case. So I find it hard to believe that you didn't know 3 years ago or 4 years ago when this started, and apparently you didn't do anything about it. How do you answer that?
We were not notified about any of this beforehand. So we understand that it's addressed to us. We have not received any statements for it, Your Honor.
How is that possible if it's mailed to you at that address?
I do not know. We had mail interference taking place. We've had an issue with our neighbor that's in a separate litigation case, so we had to get a P.O. box. We've had communication from this plaintiff before and have been able to deal with them on other matters. But this particular credit card, we do not know. We're unfamiliar with all of it, and we understand the evidence brought forward. But this is the first time it's been brought to our attention was February 4th of this year being served.
So what have you done since February 4th of this year to dispute this matter?
We've gone to the credit bureaus to dispute it, and then we've been following the different timelines with this court with filing the proper responses and then the discovery.
Did you report it to the police?
No, we haven't reported it to the police.
Why not?
You're
You're telling me that somebody fraudulently used your account.
We have not reported it to the police, Your Honor. We wanted to see what would happen with court or if there was any resolution or information to be provided with the plaintiff.
Now that you got it, what are you going to do?
And file a police report.
Counsel, is there anything else that you want to say?
Judge, the bill of sale, there's an attachment on there which does provide a lot of data as to the defendant. So when he opened the credit card, it looks like he would have provided a lot of information on here. I mean, there's an email address on here that was attached. There's also his social security number and his current address, his date of birth. So the email itself is bgoo, I'm having a hard time pronouncing the last name, but then it's 31514@gmail.com. I think that's pretty identifiable, Your Honor. I'm just asking the court to grant judgment this time.
Any further response, Mr. Goff?
No, Your Honor.
All right, I find that there is, by preponderance of the evidence, proof that the defendant has made the purchases and the payments, given the fact that it was sent to his address on multiple months, as indicated in the motion for summary disposition documentation attached to the motion. It was sent to him with his name at the same address, 3311 Fishbacks Trail in Gaylord, for multiple months, as included in the documentation, and shows purchases in November and December and a separate payment on a separate account, a separate statement in January for $77, purchases totaling, I believe, $288. So that is, in my mind, that's preponderance of the evidence that they have given proper notice. I don't believe him when he tells me that he was just waiting in order to make a proper report to the police. He's had information about this since apparently February this year, so I find that answer to be disingenuous. I'm going to grant judgment in favor of defense, in favor of plaintiff for the amount requested, $520.72 plus court costs, service fees and motion fees, and statutory attorney's fees totaling altogether $691.97. We'll send copies of that out. Thank you all very much. That's all.
Thank you, Your Honor.
Thank you, everybody. Have a good rest of your week.